Supreme Court splits 5-4 to grant Trump emergency relief in Alien Enemies Act deportation litigation. A divided Supreme Court vacated temporary restraining orders issued by a federal judge in D.C., which had halted certain deportations under the Alien Enemies Act. The court split 5-4, with Republican appointees in the majority, and Trump appointee Amy Coney Barrett dissenting alongside the court's 3 Democratic appointees. See, now that's where I'm a little bit surprised. I saw that it was 5-4, and I was sitting there going like it was probably Roberts with the liberals and the other 5 going, and no, it was Roberts in the majority and Amy Coney Barrett who is deciding to, side with the liberals yet again. So I'm like, whoa, that's nuts. The majority framed a matter as mere procedural disagreement. Dissenting judges cited loftier issues at play, but let's go ahead and see this real quick because, since it's only 25 pages and we've gone over longer ones in the past. They're like, Dobbs v. Jackson. So here we go. Supreme Court of the United States, Donald J. Trump, President of the United States et al. Versus JGG et al. Per curiam, this matter concerns the detention and removal of Venezuelan nationals believed to be members of the Tren de Aragua, an entity of the State Department designated a foreign terrorist act or whatever. D.C. Circuit denies. We grant the application and vacate the TROs. The detainees seek equitable relief against implementation of the proclamation and against their removal under AEA. They challenge the government's interpretation of the act and assert that they do not fall within the category of removal alien enemies. We do not reach those arguments. Of course they don't. Why wouldn't they reach those arguments? Challenges to removal under AEA, a statute which largely precludes judicial review, according to Ludecky versus Watkins, must be brought in habeas. So, i.e., you have to make your own habeas corpus. But that implies that these individuals have the ability to make a habeas complaint before they're shipped off to El Salvador. I mean, maybe this should be maybe this should be a frickin' frat man rant, and I'll probably get into some ranty stuff about it as we go back and forth. But yeah, how are you going to file a writ of habeas corpus if they ship you off and deport you? Who are you going to file the writ to? The El Salvadorian government? No, stupids. Regardless of whether the detainees will formally request release from confinement because their claims for release necessarily imply the invalidity, their confinement and removal under the AA, their claims fall under the core of the writ of habeas corpus and thus must be brought in habeas. An immediate physical release is not the only remedy under federal writ of habeas corpus. Peyton versus whatever. A capital prisoner may seek to overturn his death sentence in habeas analogy. For core habeas petitions, jurisdictions rely only in one district, the district of confinement. The detainees are confined in Texas. Some of the detainees are confined in El Salvador, you dumbasses. I hope the dissent said that. The detainees also sought equitable relief against summary removal. Although judicial review under AA is limited, we have held that an individual subject to detention and removal under that statute is entitled to judicial review as to questions of interpretation and constitutionality of the act, blah, blah, blah. Under the proclamation, the term alien enemy is defined to include all Venezuelan citizens 14 years or older who are members of TDA, are within the United States, and have not actually naturalized or lawful permanent residents. The detainees' rights against summary removal, however, are not currently in dispute. The government expressly agrees that TDA members are subject to removal under the Alien Enemies Act, blah, blah, blah. It is well established that the Fifth Amendment entitles aliens to due process of the law, even though many conservative, MAGA, hypocrite idiots who don't understand the Constitution will tell you that constitutional rights are only for the citizens of the United States, but clearly there are Supreme Court precedents to say that, and at least this affirms that, even though it's still ruling in the stupid. The detainees are entitled to notice and opportunity to be heard appropriate to the nature of the case. More specifically, AEA detainees must receive notice after the date of this order that they are subject to removal under the Act. This notice must be afforded with a reasonable time and in such a manner that will allow them to actually seek habeas relief in the proper venue before such removal occurs. What about the people who have already been removed? For all the rhetoric of the dissents today, as order and per curiam confirmation of the detainees subject to removal orders under the AA are entitled to notice and an opportunity to challenge their removal. Yes, but do we trust that the administration is going to allow them to have that? That's the problem. We don't trust that because the administration has already shown themselves to not want to follow court orders in the past, so why are they going to follow court orders now? The only question is the court will resolve that challenge for reasons set forth. We hold the venue lies in the district of confinement. The dissents would have the court delay resolving that issue, requiring, given our decision today, that the process begin anew down the road. We see no benefit in such wasteful delay. Oh, so now they're the Doge of the Supreme Court, eh? It is so ordered. Justice Kavanaugh concurring. I agree with the court's per curiam opinion. Importantly, as the court stresses, the court disagreement with the dissenters is not over whether the detainees receive judicial review. All 9 members of the court agree that judicial review is available. The only question is where that judicial review should occur. The president has already kicked people out. I agree with the court's analysis that the claims must be brought in habeas. I add only that the use of habeas for transfer claims is not novel. The extradition blah blah blah, Gitmo, blah 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 blah. So he agrees, and whatever. Justice Sotomayor, with whom Justices Kagan and Jackson join, and with whom Justice Barrett joins as to Part 2 and 3, B, descending. 3 weeks ago, the federal government started sending scores of Venezuelan immigrants detained in the United States to a foreign prison in El Salvador. It did so without any due process of law, under the auspices of the Alien Enemies Act, a 1798 law designed for times of war. Between the start of these removals and now, a district court has been expeditiously considering the legal claims of a group of detainees, hereafter plaintiffs. Yeah, why are they not all considered habeas petitions if it's done as a group? Huh? Who allege that their summary removal violates the Constitution and multiple statutes. The district court ordered a pause on plaintiffs' removals until it can consider their motion for a preliminary injunction at a hearing tomorrow, April 8th. Still, a majority of the court sees fit to speak to this issue today. Critically, even the majority today agrees, and the federal government now admits that individuals subject to removal under the Alien Enemies Act are entitled to adequate notice and judicial review before they can remove. Did everybody get that adequate notice? Did the hairdresser get the adequate notice? Did the Maryland guy get the adequate notice? No. That should have been the end of the matter. Yet with bare bones briefing, no argument, and scarce a time for reflection, the court announces that legal challenges to an individual's removal under the Alien Enemies Act must be brought in habeas petitions in the district where they are detained. The court's legal conclusion is suspect. The court intervenes anyway, granting the government's extraordinary relief and vacating the district court's order. It does so without mention of the grave harm plaintiffs will face if they are erroneously removed to El Salvador, or regard for the government's attempts to subvert the judicial process throughout this litigation. Because the court should not reward the government's effort to erode the rule of law with discretionary equitable relief, I respectfully dissent. The case arises out of the president's unprecedented peacetime invocation of wartime law, known as the AEA, enacted in 1798. Let's see, that's a history of whatever, blah, blah, blah. To that end, the act grants the president the power to detain and remove foreign citizens of a hostile nation or government when there is declared war with such nation, when a foreign nation threatens invasion or predatory incursion against the territory of the United States. Before today, U.S. presidents have invoked the AEA only 3 times, and in the context of an ongoing war: 1812, World War I, World War II. That changed March 14th, 2025, when President Trump invoked the AEA to address an alleged invasion of the United States by Tren de Aragua, a criminal organization based in Venezuela. See invocation of Alien Enemies Act regarding the invasion of whatever his executive order. There is, of course, no ongoing war between the United States and Venezuela, nor is Tren de Aragua itself a foreign nation. The president's proclamation nonetheless asserts that Tren de Aragua is undertaking hostile actions, conducting irregular warfare against the territory of the United States, both directly and at the direction of the Maduro regime in Venezuela, which, of course, I'm sure he's provided no proof of. Congress requires the president to make public proclamation of his intention to evoke the AEA. President Trump did just the opposite in what can be understood as only covert preparation to skirt both the requirements of the act and the Constitution's guarantees of due process. DHS began removing Venezuelan migrants from immigration and customs enforcement detention centers across the country to the El Valle Detention Center in South Texas before the president even signed the proclamation. The transferred detainees, most of whom were denied past or present affiliation with any gang, did not know the reason for their transfer until the evening of Friday, March 14th, when they were apparently pulled from their cells and told they were deported the next day to an unknown destination. Suspecting that the president had covertly signed a proclamation invoking the AEA, several lawyers anticipated their clients' imminent deportation and filed a putative class action to the District of Columbia. They contested that Tren de Agua had committed or attempted the kind of invasion or predatory incursion required to invoke the AEA. They also asserted that they would violate the Due Process Clause, yada yada. In the early morning, the District Court informed the government of the lawsuit and scheduled an emergency hearing. Despite knowing the plaintiffs' claims that it would be unlawful to remove them under the proclamation, the government ushered the named plaintiffs onto planes along with dozens of detainees, all without any opportunity to contact their lawyers, much so less without notice or opportunity to be heard. I.e., they weren't heard. I.e., they were sent off without given due process. They were sent off without given the ability to file a writ of habeas corpus to protest their unlawful incarceration, deportation, etc. But yet these idiots in the Supreme Court, the five, including Roberts, and for some reason excluding Barrett, shockingly enough, they decided that they were going to just look the other way. Just look the other way, I suppose. The government's plan, it appears, was to rush plaintiffs out of the country before the court could decide whether the president's invocation of the AEA was lawful, whether these individuals were in fact members of Tren de Aragua. Plaintiff JGG, for example, had no chance to tell the court that the tattoos causing DHS to suspect him of gang membership were unrelated to a gang. He avers that he is a tattoo artist who got an eye tattoo because he saw it on Google and thought it looked cool. Recognizing the emergency the government had created by deporting plaintiffs without due process, the district court issued a temporary restraining order. That same morning, the order prohibited the government from removing the five named plaintiffs, including JGG, GFF, who had been on a plane for about 40 minutes to an hour as crying and frightened individuals were forced on board, was subsequently retrieved from the plane by a guard who told him he just won the lottery. The court then set an emergency hearing for 5 p.m. that same day, which had planned to consider the plaintiff's claim that temporary relief should be extended to a class of all non-citizens subject to anticipated proclamation. See 2005 WL, blah, blah, blah. Despite notice of the government that the court-scheduled hearing, DHS continued to load up the two planes with detainees and scheduled their immediate departure. Government counsel agreeing that DHS was acting in preparation of the proclamation before it was posted, not until an hour before the district court's hearing, and only moments before the government planned to send its planes off to El Salvador did the White House finally publish the proclamation on its website. At its 5 p.m. hearing, the district court provisionally certified a class of Venezuelan non-citizens subject to the proclamation. Then it issued an oral temporary restraining order prohibiting the government from removing all members of the class pursuant to the proclamation for 14 days. The order did not disturb the government's ability to apprehend or detain individuals pursuant to the proclamation or its authority to deport any individual under the Immigration and Naturalization Act. All it required of the government was a pause in deportations pursuant to the proclamation until the court had a chance to review their legality. But these conservatives are in such a damn hurry to get these people out because they don't measure twice before cutting once. And I've said this before, I've said this again, and apparently even Joe Rogan agrees with me, that this administration needs to measure twice before cutting once. But they're not doing that. They're purposely rushing things and knowingly making errors and mistakes because they don't care, because to them it's not a bug, it's a feature. The ability to be able to deport people who aren't white out of this country, who they can, terrify you with and claim, oh, these are all gang members when they're not, is just part of their plan. It's part of their designs. It's part of their attempts to, ignore the rule of law in this country. Concerns about the government's compliance with the order quickly followed. Even now, district court continues to investigate what happened via a show cause proceeding. In those proceedings, the government took the position that it has no legal obligation to obey the district court's orders directing the return of planes in flight because they were issued from the bench. Of course, as the government well knows, courts routinely issue rulings for the bench, and those rulings can be appealed, including this court, in appropriate circumstances. The district court, for its part, has surmised that the government knew as of 10 a.m. on March 15th that the court would be holding a hearing later that day, yet it hustled people onto those planes in hopes of evading an injunction or perhaps preventing individuals from requesting the habeas hearing, which the government now acknowledges they are entitled to. So the government now acknowledges in court that these people are entitled to habeas corpus hearings, but can provide no example of all of these people who were kicked out before being granted habeas corpus hearings. And people don't understand why we're upset with Donald Trump, why we're pissed off with Doge, why we're mad at Elon Musk and all these fascist Nazi dictator wannabe bullshit folks. Because I don't care about the language right now. They're like, oh, what they're doing is not wrong. Clearly, if they're rushing to get people on the planes because they don't want to have to hear a court ruling, then that should not only be seen as being suspicious at the very least, that should also be seen as being frickin' in contempt of court, or at least trying to have contempt of court, or showing contempt of the court because they were like, well, we're going to do this anyway, regardless of how this judge rules. That should be contempt 101. The deportation directly into SCOTUS presented a risk of extraordinary harm to these plaintiffs. The record reflects that these inmates in Salvadorian prisons are highly likely to face immediate and intentional life-threatening harm at the hands of state actors. SCOTUS detainees are frequently denied communication with their relatives and lawyers and only appear before courts at online hearings, often in groups of several hundred detainees at a time. El Salvador has boasted that inmates in SCOTUS will never leave, and plaintiffs present evidence that inmates are rarely allowed to leave their cells, have no regular access to drinking water, adequate foods, sleep standing up because of overcrowding, and are held in cells that do not see sunlight for days. One scholar attests that an estimated 375 detainees have died in Salvadorian prisons since March 2022. What if the government later determines that it sent one of these detainees to SCOTUS in error, or a court eventually decides that the president lacked the authority under the Alien Enemies Act to declare that Tren de Agua is precipitating or attempting an invasion against the territory of the United States? The government takes the position that even when it makes a mistake, it cannot retrieve individuals from Salvadorian prisons to which it has sent them. See Defendant's Memorandum of Law in opposition to Abrego Garcia versus Nome. The implication of the government's position is not only non-citizens, but United States citizens could be taken off the streets, forced into planes, and confined to foreign prisons with no opportunity for redress if judicial review is denied unlawfully before removal. History is no stranger to such lawless regimes, but this nation's system of laws is designed to prevent, not enable, their rise, even as the government has continued to litigate whether its March 15th deportations complied with district court's orders. It simultaneously sought permission to resume summary deportations under the proclamation. The district court first denied the government's motion to vacate its TRO. The president's authority and discretion under the Alien Enemies Act is not proper, subject for judicial scrutiny, blah, 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 blah. It is only this court that sees reason to vacate for the second time this week a temporary restraining order standing on its last legs. Department of Education, blah, 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 not content to wait till tomorrow when the district court will have a chance to consider full preliminary injunction briefing at a scheduled hearing. This court intervenes to relieve the government of its obligation of the order. Begin with that upon which all 9 members of the court agree. The court's order today dictates in no uncertain terms that individuals subject to detention and removal under the AEA are entitled to judicial review as to questions of interpretation of constitutionality of the act, as well as he or she is in fact an alien enemy 14 years of age or older. Therefore, under today's order, courts below will probe, among other things, the meaning of an invasion or predatory incursion and ask, for example, whether any individual is in fact a member of Tren de Aragua. Even the government has now largely conceded that point. So too do we all agree with the per curiam's command that the Fifth Amendment requires government to afford plaintiffs notice after the date of this order that they are subject to removal of the act. Of course, what about the people who removed before? Within reasonable time and in such a manner that will allow them to actually seek habeas relief in the proper venue before such removal occurs. This means, of course, that the government cannot usher any detainees, including plaintiffs, onto planes in the shroud of secrecy, as it did on March 15, 2025, nor can the government immediately resume removing individuals without notice upon a vacatur of the TRO, as it is promised. To the extent the government removes even one individual without affording him notice and a meaningful opportunity to file and pursue habeas relief, it does so in direct contravention of an edict by the United States Supreme Court. In light of this agreement, the court's decision to intervene in this litigation is as inexplicable as it is dangerous, right? Because, again, compare this to Shelby versus Holder, right? Shelby versus Holder was a ruling that overturned Section 4, I think, of the Voting Rights Act, either 3 or 4, because whatever. There's a video on that on my channel. But Shelby versus Holder, what it basically did, or what Justice Roberts said in that act said in that ruling, was that the Civil Rights Act, the Voting Rights Act, the provisions, the pre-clearance that was required of certain states that have proven themselves to not be able to be trusted when it came to passing certain laws, when it came to voting rights, that the Department of Justice had to give those states pre-clearance before they could go ahead and get these bills put into law, either put before the voters or voted on, or etc. Or before it could go into effect, it needed pre-clearance by the Justice Department. The Justice Department would say yay or nay. And the ruling by Supreme Court's Chief Justice Roberts was that because we've not seen the racism that necessitated the creation of the Voting Rights Act and that particular section of the Voting Rights Act, because we haven't seen that level of racism in decades, that we don't need it anymore. Much like the fact that us here in New Orleans, we clearly don't need the levee protection system to protect us from flooding from the river, because the river hasn't flooded us in over a century or whatever. But the reason that the river hasn't flooded us is because of the levees. You take down the levees, we flood. The reason that those states were not able to commit the acts of extreme racism when it comes to, enforcing racist laws as part of their election code is because of the preclearance. Without the preclearance, these states, the flood walls open, the floodgates open, whatever, and these states were able to pass all of these racist laws, including these so-called voter ID laws that contain other provisions that have nothing to do with the requirement to show an ID. So, just like this, they seem to think that, just because we have this saying that the Supreme Court has said that everybody is entitled to file a writ of habeas corpus to protest their detention and their deportation, and because of that, the government has to give notice. But the government hasn't given notice. The government hasn't done what they are supposed to do, what they were supposed to be doing up until this point. So why do we believe now that the government will now do what it was supposed to do when it should have been doing it back then? The government has acted in a very untrustworthy way. The government has acted in a sneaky, suspicious, horrible, evil way. But yet the five on the Supreme Court seem to think, we'll just believe them if we tell them that they have to do it now, then we're just going to believe them. Hilk, hilk. I mean, how goofy can you get, right? Anyway, so the court's ruling today means that those deportations violated the Due Process Clause, most fundamental protections, blah, blah, blah. The district court rightly intervened to prohibit temporarily the government from deporting more individuals in this matter based on correct assessment that the plaintiffs were likely entitled to more due process against the backdrop of the U.S. government's unprecedented deportation of dozens of immigrants to foreign prisons without due process. A majority of this court sees fit to vacate the district court's order. The reason apparently is because the majority of things plaintiffs claim should have been styled as habeas actions and filed in the districts of their detention. In reaching that result, the majority flouts well-established limits under its jurisdiction, creates new law on the emergency docket, and elides the serious threat our intervention poses to the lives of individual detainees. As an initial matter, the court lacks jurisdiction to review the district court's time-limited interlocutory order. It is well established that generally temporary restraining orders are not appealable. That rule is a general one because it gives way where a temporary restraining order risks imposing such irreparable consequences that an immediate appeal is necessary if the order be effectually challenged at all. Here, the district court ordered a 14-day halt on deportations pursuant to the proclamation because it thought the plaintiffs were likely entitled to individualized hearings to determine whether the act applies to them all. The government now admits that it must provide detainees with adequate notice, and it says that they can file habeas petitions in the Southern District of Texas to contest and stay the removal under the Alien Enemies Act. Such proceedings, if adequately provided, necessarily mean that the government cannot imminently deport the plaintiffs under the proclamation. So it is hard to see why the district court's temporary restraining order, of which only 5 days now remain, presented the government with an emergency of any kind, much less one that required an immediate appeal. Also troubling is the court's decision to vacate summarily the district court's order on the novel ground that the individual's challenge to his removal under AEA falls within the core of the writ of habeas corpus and thus therefore be filed where the plaintiffs are detained. The court reaches that conclusion without oral argument or benefit of the percolation in the lower courts, and with just a few days of deliberation based on bare bones briefings. This conclusion is dubious as an initial matter. The majority's assertion that plaintiffs' claims sound in habeas is in tension with this court's understanding of habeas corpus as its core, an avenue for a person in custody to attack the legality of that custody to secure release from illegal custody. The plaintiffs in this case sued not to challenge their detention but to protect themselves from summary deportation pursuant to the proclamation. Indeed, because of all of the plaintiffs were already in immigration detention under other statutes when the government subjected them to proclamation. They have repeatedly emphasized throughout this litigation that they do not seek release from custody, and they are not contesting the validity of their confinement or seeking to shorten its duration. Nevertheless, the majority insists the plaintiffs' claims unnecessarily imply the invalidity of their confinement and removal under the Act, and so essentially amount to a challenge of their present physical confinement, which is just stupid, because habeas... Thank you, Molly, very much for the super chat. Appreciate you. But yeah, so there are also good reasons to doubt that Heck's holding about the availability of the relief under 1983 extends to Administration Procedures Act. The Heck Bar arose. It's a trap! The Admiral Heck Bar, arose from the court reading an implicit exception into 1983 to avoid swamping the habeas statute's coverage of claims that the prisoner is in custody in violation of the Constitution. The court has never limited the availability of APA relief so narrowly. To the contrary, the APA has been long available to plaintiffs absent specific preclusion by Congress. Although the APA allows courts, we can skip that, blah, blah, blah. Let's just go on more and more and more. Let's just see what anybody else had to say or get to the conclusion. The government's conduct in this litigation poses an extraordinary threat to the rule of law. That a majority of this court now rewards the government for its behavior with discretionary equitable relief is indefensible. We as a nation and a court of law should be better than this. I respectfully dissent. Justice Jackson, I enjoy Justice Sotomayor's defense in full. Let's kind of scroll down. I lament that the court appears to have embarked on a new era of procedural variability, and that it has done so in such a casual, inequitable, and in my view, inappropriate manner. And that was it. At least when the court went off base in the past, it left a record so posterity could see how it went wrong. See Corpus versus United States. With more and more of our most significant rulings taking place in the shadows of our emergency docket, today's court leaves less and less of a trace. But make no mistake, we are just as wrong now as we have been in the past with similarly devastating consequences. It seems we are just less willing to face it. Again, why on earth would the 5 members who were conservatives and who actually, have no brains, I guess, why would they trust this administration when it came to, I don't know, anything that it says about anything whatsoever? They proved themselves to be not trustworthy because they were trying to rush the people out of the country before the court could rule. If that's the type of, that is literally the type of behavior that is done by criminals. Or children who are get caught with their hand in a cookie jar. Like, let's get all the cookies out of the cookie jar before mom comes home and catches us, and we're going to take the cookies to our room. Like, that's the type of childish, illegal, immoral, and unethical behavior that this administration is all about. And yet the 5 on the Supreme Court that supported the administration's request for emergency relief just want to be like, oh, well, since we said you have to do it, we're going to trust that they're going to do it. No. Verify that they're going to do it. And then afterwards, you can maybe trust that they are doing the right thing. But I'm never going to trust that the Trump administration is going to do the right thing simply because of the fact that they've proven themselves time and time again that they are not worthy of that feeling or trust or whatever. They are unworthy of that. So yes, this is becoming a fat man rant because you have innocent people being deported and you have the potential of other people who could very well be deported without being given the opportunity to show that they are innocent. It's not even their requirement. The requirement is on the government to show that they are guilty. The government has that requirement. The government should always have the requirement to prove guilt, not put on the defendants or the impending deportees. It's not up to them to have to prove their innocence. They should never have to prove that they shouldn't be deported. They should not have to prove, that them being deported is an illegal thing. Government should have to prove that each and every act of deportation is a legal action, and it should have to be done in a court of law. But I guess the Supreme Court, just wants to only do it, I guess, now, and not. Where's the Supreme Court when with the other people who've already been deported, who were denied the ability to file a writ of habeas corpus? Huh? Where's that? What happens to them? How do you enforce that? Because this administration was so rushed try and get this out of the way, and because they refuse to measure twice before cutting once. We should all be dissenting at this point. When you're criticized by Joe Rogan for doing the wrong thing, what else can I say? Joe Rogan even has this one right. But the 5 idiots on the Supreme Court who are backing Donald Trump for whatever God knows reason, because the dissent had it dead on accurate here, more people are going to get deported. No, I don't trust that this administration is going to give adequate notice. I don't trust that this administration is going to allow these people to file the writs of habeas corpus, give them the time to do it, etc. And the fact that they're in Texas means that if the Texas cases fail, and they're most likely going to fail, what's it going to go? It's going to then go to the Fifth Circuit Court of Appeals, which is the most conservative court of appeals in the nation. And then once they fail there, because they're going to fail there, because if they fail at the District Texas Court, they're likely going to fail at the Fifth Circuit. So then it has to come right back to the Supreme Court, who is then going to decide whether or not they're going to agree to hear it or not. But they've created this monster already. And they're probably going to choose to not deal with it. I will be shocked if any of these cases make it back up to the Supreme Court through their habeas corpus petitions, and then the Supreme Court says, okay, we'll hear the case now. Do trust this administration at your peril. That's all I'm going to say. To judges, to politicians, anybody else. If you trust this administration, you do so at your peril. What do you think? Agree with me, disagree with me? Leave your comments down below. Remember to like the video, share it, subscribe to the channel. And unless you're a Nazi or support the actions of this horrible president, which I don't see the difference, have a good day.